Every day in the USA, people find themselves in court.
This is the state of Michigan versus John Lee Wyman, 26-01280. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf.
Assistant Public Defender Justice Straub on behalf of Mr. Wyman, who is standing to my right.
Mr. Wyman, this is an assault and battery pretrial today, and then also a bond violation, alleging that he had third-party contact with the protected party. How are we proceeding today?
Your Honor, we will be contesting the violation.
Was there an offer?
There's no offer, Your Honor. People are prepared to move forward with the PA 52 violation.
Today?
Yes.
So you want a final pretrial on the other matter, or what do you want? The trial?
We can set for trial, Your Honor.
Okay. You call your witness.
The people called Stephen Collins.
I am gonna bring things up after this.
Let me come.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, I do.
You can have a seat, sir. State your first and your last name and then spell both.
Stephen Conklin, STEPHEN
You can proceed now.
Thank you, Your Honor. Mr. Conklin, I'm going to ask you a couple questions about an incident that brings you into court today. So, give me a second. Start off by asking you some questions about this matter that took place on May 15th of 2026.
Okay.
Are you familiar with that date?
Yes, I am.
And, is there and there was a underlining issue that brought you to the court before that particular date. Do you remember that incident? The assaults?
Yes.
Okay. There's someone here that you filed assault claims on prior to this May 15th incident.
Yes.
Can you point that individual out and describe an article?
John.
Your Honor, may the record reflect that the witness has identified the defendant.
Any objection? So noted.
So there was a previous assault claim that you filed against the person, right?
Yes, sir.
You remember what date that was?
3 days before the people showed up in the house.
Okay. So prior to the people showing up at this particular incident, you filed an assault charge.
Yes.
And to your knowledge, strike that. So tell us on May 15th, were you at 1822 Rex Street in Lansing?
Yes, it was.
And is that your address where you live?
At that moment, yes.
Okay. And can you describe how you came to live at that address?
After speaking with John, John offered me a trailer for rent that was in his backyard at the time. I was eventually moved into the 1-bedroom, and then it moved to 2.
2 bedrooms in the trailer?
No, in the house.
In the house. Okay.
Yes.
And then on sometime before May 15th, John assaulted you, right?
Correct.
And then on May 15th, after you filed charges for assault, tell us what happened on May 15th.
I left to go to the store with my kids. I came back, tried going into the back door, wouldn't work.
And you have to keep your voice up a little bit because the judge
Tried going into the back door, it wouldn't work. Stepped out, there's like a little breezeway right there, stepped off the back porch. John's truck pulled up, two gentlemen stepped out, one Hispanic, one white.
And you said John's truck pulled up. Was
Uh,
John in the truck when
no.
it pulled up? Okay, cool. But you recognize that as John's truck?
Yes, sir.
Okay, all right. Tell us what happened when it pulled up.
There's two people started being belligerent, basically demanding I leave, threatening to hit me in the head with a hammer. Wouldn't let me go into the house once they went in. Basically refusing me to get my stuff after begging them to go and get my stuff. I therefore spoke with my family member, which heard everything going on. And then they called the cops.
And these two, you said there was a Hispanic individual and you say what, Caucasian individual?
Yes, sir.
Did you recognize those people before? Had you seen them before?
I had seen one in passing, but dealing with different entities, but no, I have not had relations or dealt with them.
How'd you know that the defendant sent those people to that address to confront you?
The two people informed me that John sent them over there in his truck, and that John had full intentions of coming back to that address when he got out of work.
In order to remove you or to kick you
No, I
out?
was supposed to be already gone, according to these two.
Okay, so to prevent you from getting back into this.
That's it.
And this all took place in the city of Lansing, right?
Yes, sir.
Ingham County, state of Michigan?
Yes, sir.
All right, thank you. No further questions.
John, she's,
John's just an associated friend.
okay, how did you come to meet him?
Met him through social media.
Okay. And so tell us how you go from social media to moving into his home.
We talked. He was informing me of some poor things or some bad things that happened in his life. I was informing him of some bad things that happened in my life. Told him that I had my son, and he had offered me the trailer out back, and I did not move on that until 3.5 weeks after.
Okay.
Then in that 3.5 weeks, it had went from the trailer to a bedroom. Then he had another person living with him, which I was going to be their stepson. He went to jail, and then it moved to 2 bedrooms.
Okay. So when you moved in, you didn't move in directly into his home. You moved first into a trailer.
No,
Okay.
no. The trailer was offered.
Okay.
Within the 3.5 weeks of me waiting to move in there,
Mhm.
I had to fix my truck so I could work to be able to pay him. It had changed to the trailer to the inside the house. When me and John were talking, I said, "Oh, I must have upgraded."
Okay. Oh, so he was kind to you. He offered you
Yes,
a better circumstance. Okay. And how much did he charge you for that?
400.
Okay. And did you ever pay that 400?
Yes, it did.
I'm gonna object to relevance.
What's the relevance?
I see.
There's an objection to relevance, so you don't have to respond until I instruct you whether or not you can give the answer or not.
Part of the defense's theory, Your Honor, is that Mr. Wyman was simply availing himself to the benefits of the law through an eviction process.
By sending two people over.
Whoa. What lawful eviction allows this? I'm confused.
So, Your Honor, we are contesting actually that Mr. Wyman sent 2 people. We actually have a video of the proof of service. We also have another
Service of what?
of the 7-day writ, Your Honor.
Okay, so you believe that your position is that there was proof of service of an eviction.
Yes.
Okay, and that there, and then what? What does that have to do with whether or not you pay the rent?
That there was a basis for the eviction. as
Well, you
well.
don't, in the state of Michigan, you really don't need, you can do termination of tenancy because you just don't feel like having them there. So that, whether or not you pay the rent is irrelevant. So he doesn't have to answer that.
Okay.
But I'll let you ask whether or not he was served with a notice to vacate.
Okay. Well, let's jump right to that. Okay. Were you ever served with a 7-day writ, Mr.
The
Cox?
same day
Okay.
that them 2 gentlemen came over,
Mhm.
one, the white Caucasian gentleman,
So
was
I
the
would've-
one that came this morning
I would
and
object.
served me a 7-day notice.
It helps when you stand up. It makes me feel like you got something to say.
I'll object to this entire line of questioning for relevance. We're here because the defendant committed PA 53 violation. And I don't think an eviction has anything at all to do with uh, 53 violation, or him sending two people over to the house to contact this witness.
Objections overruled. Because if, and I don't know what she's laying foundation for now, if she's just trying to lay foundation to establish that someone was sent there to serve an eviction paperwork, that is within the realms of, he's allowed to serve an eviction on his property, even though this is pending violation for him, or pending violation for him to have no contact directly. Court order will allow him to send someone to serve that paperwork. However, this sounds like it was more than just service.
Yes.
Okay, so you said earlier in the day, could you 10:30?
10:30 in the morning, the Caucasian gentleman showed up at the door, banging on the door. I opened the door. He served me a 7-day notice. A couple hours after that, he come back with the other gentleman, then wanting to force us out of the house. I didn't know that the Caucasian gentleman was the one that was the defendant until he informed me he was the one that served me.
Okay, so someone who showed up later in the day,
The same person.
you weren't aware that.
Are
he
you
was
not
the
following
same-
me? Okay, let me say this again for you. A white gentleman showed up at the door, 10:30 in the morning, served me a 7-day eviction. That same white gentleman appeared later in the day with an Hispanic gentleman to have me removed out of the house by their way.
Okay, I appreciate the clarification. You just said that you didn't know that one of the gentlemen that came later in the day was the same gentleman. who
Now you're
served
playing
you.
on my word, because no, I didn't know. I said he made me aware that he was the one that served me when he came back the second time.
Did you or did you not know it was the same person when he came back the second time?
I didn't recognize Noah's in the morning.
Okay, well, she's not playing on your words. That's exactly what she just asked you.
No, I didn't recognize him at first. Then he informed me he was the one.
Okay, so if I were to show you an image of that person, would you be able to identify them as the person who appeared at your home
Yes, I
earlier?
will.
And you said that was at 10:30,
Approximately correct.
Your Honor, permission to approach the room?
I haven't had an opportunity.
I'm sorry. It's still shut here. Okay, do you recognize that house?
Yes, I do recognize that house. I cannot recognize that gentleman. I'm facing. This
Can
is the
you-
picture
excuse
behind.
me,
Yes,
Mr.
that is
Conklin.
But you
1822.
sir, you can only answer the questions that are asked.
1822 Rex Street.
I appreciate your testimony, sir.
Mhm.
I'm going to ask you at this point to answer my questions with yes and no responses,
Yep.
okay? So this is the home that you were living in at the time,
Yes,
okay? Does this appear to be the person that you saw that day?
I cannot answer that question.
You cannot recall?
I cannot answer that question. That picture is taken 20 yards from the house and it's on the backside of it. I can't answer that question.
Well, let's play the video a little further. Let's see if maybe you can get something that helps you become more familiar. Bear with me, it's just a minute and 44 seconds. Looks like someone has opened the door.
That would be the-
So you do recognize that?
No, I did not say it.
You said that would be you, sir.
No, I did not. I said answering the door would be me. I cannot recognize that gentleman from the backside. I don't know. As far as I know, that picture
Sir,
could
there's
be.
no question.
Okay, so when the people showed up at, you said 10:30 in the morning, Were they in possession of any weapons?
No.
Did they interact with you any more than simply handing you a piece of paper?
No, they didn't.
Okay.
They were quite respectful.
Okay. You say showed up later in the day. Did you ever get a chance to get their names? Okay.
You have to
No,
say
no,
for the record.
no, I did not.
Did you ever actually see them in possession of any weapons?
No.
Okay. However, you mentioned that they had threatened you earlier.
Correct.
Okay, but they never had any weapons.
Objection, I don't know. I will ask. Just because they don't have a weapon does not mean they can threaten.
Well, by his very testimony, he said they threatened him with a hammer.
Oh,
No.
He said, when I'm dealing with an objection, you can't respond, sir. It requires me to address the objection and then tell you if you're lawfully allowed to answer the question or not, okay? There's nothing to do with you. It has to do with the question, okay?
Correct.
Okay. The objection's overruled. You can answer the question.
Never saw anyone in possession of a hammer or a gun or any weapons.
I never did see anybody in possession of a weapon.
And you did not see my client that day. You mentioned that as well.
Correct.
Okay. Then how are you 100% sure? This time you can answer something other than yes. How are you 100% sure that Mr. Wyman is who sent them?
The two individuals informed me by verbal communication that John sent them over there to have me removed out of the house by them, let it be them hitting me in the head with a hammer or by other violence in front of my children.
Okay.
That's how I know.
So it could very well be that that was not true. You never heard from Mr. Wyman yourself that he had sent people over to your home.
No.
Thank you.
Can you redirect? Thank you. So you may be excused from the stand. Thank you.
Can I go back up?
Or you can stay here. It's up to you.
Oh, no.
You have any other witnesses?
no, the people were.
Argument. Are you calling witnesses?
I do have one witness.
You do have a witness?
I do.
Oh, okay, good.
The Vince call Michelle Horton to the stand.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
If you can have a seat. If you can state your first and last name and spell both.
Michelle Horton, MICHELE, HORTON.
Proceed. Thank you.
Just for context, Ms. Horton, how do you know or who are you to Mr. Wyman?
I've been best friends with John Wyman for over 20 years.
And how are you involved in this situation?
Because John ended up needed it after he got out of jail the first time. He needed a place to go because he couldn't go back to his house.
Okay. And on May 15th, how would you have been at all related or involved in anything that happened at that Rex Street address?
The only thing that I know of is that I rode over with Brett Melzer to give the 7-day notice or whatever, and I videoed it.
Okay.
That's the only part I have of it.
So how long would you say, well, let's start with what time do you think you would have arrived? To the best of your mind.
I'd say it was, but I would say it was about 11 because John had to be to work that day.
Okay. So when you arrived, how long would you say you were there?
Probably maybe 10 minutes because it took us that long to get him to answer the door.
Okay. And how many times that day did you go there?
Pardon?
How many times that day did you go?
I only went once.
Okay. And were you aware of any instruction from John to go back to that address later in the day?
No, I was not.
Who is Mr. Melzer? You just mentioned a Mr. Melzer. Who is that?
Clint Melzer.
Who is he?
He is a friend of mine and got to be a friend of John's for a minute. And when John got out of jail the first time, and John wanted to go get the 7-day notice, we rode down there with him to get it. I didn't go in with him. Clint did. And then the last I knew, he was supposed to be door dashing.
Okay. So Mr. Melzer is the person that went with you to serve the notice. What role did he play in that service?
He went to the door and handed it to him.
Okay. Do you see Mr. Melzer here today?
No, I don't.
Okay. Your response was it seemed to have some humor to it. Why is that?
Because Mr. Melzer's in quite a bit of trouble.
Why is that?
He stole my laptop computer. Him and his girlfriend, Alicia Matea, stole my Norco strips from Kroger's.
Mm-hmm.
And they were caught. She was caught on camera. I identified her. So she's going to go up on charges for that.
What's the relevance?
Yeah, objection.
What is the relevance to this case of a bond violation?
Well, Mr. Melzer, Your Honor, is now accused of stealing Mr. Wyman's truck. He was previously given the ability to drive that truck, but for very specific purposes, he has not complied with the scope of that
What's
authority.
that got to do with this?
Because we're alleging that Mr. Melzer went back to that property, if he did that, on his own accord.
You want me to believe that Mr. Melzer cared so much about this person's property that he took his truck to his house to do a vigilante eviction because he just had nothing else to do?
No, Your Honor, I am saying that Mr. Melzer may not be the most
Mr. Melzer's not here. Mr. Melzer's not on the stand. We are not assessing his credibility. It's her credibility at stake right now because she's testifying.
He was subpoenaed to be here today, Your Honor.
Why are you questioning her about something that has nothing to do with this? It's not relevant. Move on.
Okay. Where was Mr. Wyman's truck after this incident? Who was in possession of that truck?
Clint Melzer.
Okay. And where was that parked?
It was parked at my house at 306 Brittany. And he was told not to drive it because John.
Objection,
Hearsay.
objection. Yes.
Sustained.
Miss, I'm sorry, what did you say your name was?
Michelle Horton.
Horton, Miss Horton, were you at this property house where you served the eviction? You were there earlier in the day, right?
Yes.
You weren't there later in the day
No,
when this incident was alleged to have happened,
no.
right? Okay, no further.
Maybe excuse me. I'm thinking. Any other witnesses? Any other defense witnesses?
Yes, Your Honor, Mr. Wyman.
Raise your right. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can examine him from there.
Okay. Mr. Wyman, did you send someone to the Rec Street address for any purpose on May 15th?
To be served. With
For
the
what?
7-day rec.
Okay. For any other purpose?
No,
Did you instruct anyone to threaten Mr. Conklin?
no,
Did you ask anyone to go to that address more than once?
no,
And you didn't go there yourself either, did you?
no.
No further questions. Cross-examination.
you are Mr. Wyman. Mr. Wyman, I'm Dan Smith, I'm the prosecutor. I'm gonna ask you a couple questions about your testimony today. If you don't understand the question that I give you, you can ask me to rephrase. If you answer the question, I'm gonna assume that you've understood the question, you're answering that question.
Yes,
You agree on that?
yes.
So, Mr. Wyman, it sounds to me as if this matter arises over a property dispute, right?
Yes,
And you say that Mr. Conklin was supposed to pay your rent.
that is correct.
He didn't pay your rent.
That is correct.
And you wanted him to leave the property.
That is correct.
And he didn't leave the property.
That is correct.
So that made you upset.
I had to serve him.
My question is simple.
Yeah.
It's just yes or no.
No.
You didn't leave the property. You weren't upset that he didn't leave your property after not paying?
No,
Okay. So you just let him just stay in there, right?
Yeah.
So you didn't issue a writ.
yes, it was issued.
My question to you is, were you upset that he did not leave your property after not paying rent? Yes or no?
Objection, Your Honor, ask and answer.
Okay, so
Are you withdrawing your question?
no.
Oh, okay. The objection's overruled. You can answer.
So again, my question to you was, you said you weren't upset with him leaving, but you issued him so you didn't think that he should continue to stay, right?
Correct.
So you issued a writ,
Correct.
and you had your friend go over and serve that writ.
Right.
In your truck.
Correct.
With some other.
Not serve it. He didn't serve it in my truck.
You had your friend go over and serve a writ, right?
With Miss Horton
With Miss Horton.
in her vehicle.
You tape that, right? And she taped that,
Mm-hmm.
and
Is that a yes?
Yes.
this friend that you had go serve the writ earlier today, does he have access to your keys to your truck at all times?
No.
So on this particular occasion, he got access to your truck
Yes.
without your knowledge.
Yes.
Where are the truck keys located?
Miss Horton.
And Miss Horton's your friend, right?
Yes.
And he got the keys to your truck.
Yes.
And he got another one of your friends. This.
No.
Oh, okay.
I don't know.
So he got the keys to your truck after serving the writ. The guy who gave him the writ earlier in the day.
Yeah.
He got access to the keys to your truck.
Yes.
He went back to your property.
I did not know.
You heard his testimony.
Yeah.
So he's testified that they came back to the property. Did you hear his testimony? Were you here sitting in the courtroom? You heard his testimony, right?
Yep.
His testimony was that your friend, how long were you friends with this guy?
A day.
I'm talking about the person that you sent over to issue the writ who came back in the day. Were you only friends with him for one day?
Yes.
You let a person who were friends with one day get the keys to your truck. Is that your testimony?
Yes.
Okay. And you let this friend serve a writ for you on your behalf. Somebody you didn't know.
Correct.
Okay. And you authorized Miss, what was her name? You authorized her for that guy to get the keys to your truck.
Yes.
Okay. A person that you didn't know. You said, hey, take the keys to my truck. No problem. Go issue this writ for me. Is that your testimony?
Objection, Your Honor. I'm not sure what the relevance here is to the truck.
It goes to his credibility.
This definitely goes to credibility.
For who, Mr. Melzer or for Mr. Wyman?
Mr. Wyman.
So do you need me to repeat the question?
Yes.
My question is, you let a person who you had no clue who this guy was, right?
Correct.
You authorized him to get the keys from Miss Melsner,
Miss Horton.
Miss Horton. You authorized him to use your vehicle that day.
I was dropped off at work.
Do you remember the question?
Yes.
The question was, you authorized that guy who you didn't know to get the keys to your truck to go issue a writ, right?
No.
No, his
So,
testimony
okay,
was that
so-
the truck wasn't used to issue the writ. They
Okay.
went in Miss Horton,
Miss Horton.
Miss Horton's vehicle to
Okay,
issue the truck.
okay.
Then he later gave this person that she testified they had became friends, but he said he has now testified that they just met each other. He gave the car to his truck to him that day
Okay.
for whatever purpose.
So, some time later, this person that you didn't know got the key. So he didn't have keys to your truck earlier, but sometime later in the day, he got the keys to your truck, and you heard him testify that individual went back over to the house and threatened.
Yeah.
Right. And this person that you did not know, and who did not know the guy who testified, went or it's your testimony that individual went back to the house to threaten this person, and it wasn't at your request.
That is correct. It was not at my request.
And do you believe that testimony is reasonable? Do you believe it's reasonable for a guy who didn't know him, didn't know the complaining witness, and who doesn't know you, will go over to a house and threaten someone because he didn't pay you rent? Is that reasonable?
No.
Oh, I agree. It's not reasonable. No further questions.
Can you redirect?
John, was Clint a mutual friend between you and someone else?
Yeah.
So it wasn't like you had just met him the day before on the street, right?
Right.
Okay. So you kind of had a reason maybe to, I want to say trust, but to believe that maybe giving him.
Are you asking him a
I'm sorry.
direct question or a leading question?
I'm trying to ask a yes or no question.
This is your witness. You can't ask him a yes or no question. So it's did you have a reason to trust him versus suggesting the answer?
So did you have a reason to trust Clint?
Yeah.
Okay. You were dropped off at work, correct? That's before the service. They used your truck to use. Why? How did you get to work?
I drove my truck to work.
And then how did your truck go to work?
Because you
Your Honor, I didn't hear the question. I'm sorry.
How did it get to?
How did your after you went to work? How did your truck get to work?
he
I would say objection. Also respect.
Your Honor,
How's his truck? I think he should know how his truck got there. I'm also that objection. You can answer the question.
Okay.
Is that the person's name?
The question is after John
Yes, not in the
drove.
report, Your Honor. Yes,
How-
his name's Clint.
Yeah.
Okay, who is Clint?
This,
I don't know. That's what I'm at.
the person who served him, 70 rep.
the person.
Okay, this is causing confusion because 7-day writ was not served in the truck, correct?
Correct.
No, Your Honor. I just want to
Oh,
clarify that Clint is the individual that Mr. Smith was just saying, questioning as to John's credibility as to why he would give him his keys.
I think it was another person. I thought.
No, it was Clint.
It was Clint. What's Clint's full name?
Clint Melzer.
Okay, let's use it. Let's be consistent with the name so we don't get confused because there are two males alleged to be involved. So so it's the same person you're talking about.
I guess. I mean, I didn't know who the person was. But
Clint Melzer. Okay.
Clint Melzer.
so my objection is a call for speculation because it says he was dropped out at work, and I don't believe there was a foundation for him to say how the truck got well.
Did he give him? I thought he was allegedly giving his truck to the person.
Your Honor, if I may. So the prosecution is essentially saying that.
The objection's overruled. He can answer the question.
So after you drove to work, how did Clint get your truck?
After I was dropped off at work, he asked if he could use my truck to do DoorDash. That's the last I knew.
Okay. Did you ask him to go do the service along at any point?
That was earlier with Miss Horton.
Okay, so after, I just want to make sure the timelines are right. So after Clint Melzer had performed the service, you allowed him to go use the truck for him.
Yes.
No further questions, Your Honor.
I have just a couple follow-up questions. If everyone's referring to a writ, you had a lawful eviction that was in process during that time?
Yes, it was.
Okay, and a writ had been issued?
Yes, it was.
Okay, and so did you tell law enforcement that you were of the understanding that you could tell Mr. Melsner and the other person to go lock your property up to secure it?
Yes.
So why are you now acting like you didn't know that they were going over there?
Mr. Melsner went over by himself to lock my doors, which he did. Nobody was there.
How do you know that?
Mr. Melsner said that to me.
When did he go over there by himself to do that?
After I was dropped off at work,
You sent somebody back over
I
there.
asked him to go and check
Thank
to
you.
see if anybody was there. I locked my door.
Argument.
I think it's clear, Your Honor, that at any rate, that the defendant could have used the police if he had a lawful writ, or if he was under the eviction process. There's a right way and a wrong way to do it. You don't send your friends, a person that you trusted with your truck, to use DoorDash, and now you're coming to court saying that this might have been a friend or wasn't a friend, or he did this on his own. I think it's clear. The defendant claimed that his own story wasn't reasonable. It's not reasonable to believe that the defendant did not send them back over there to do self-help and to lock this place up when he should have used the police. So based off of the testimony that you heard in the credibility of this witness testimony, I'm asked that you find guilty of the PA.
Yes, Your Honor.
Actually, I might spend it some yard.
Thank you.
Your Honor, I don't think it is the service that is in question. I think that what the prosecution's theory is that later in the day, when these two men, who one of them is presumed to be Clint Melzer, we don't know because the police report does not accurately identify who exactly the two men were. That's kind of what we're inferring based off testimony from Mr. Conklin. Now, Mr. Wyman has a fundamental right to pursue an eviction process. There is a genuine question as to whether Mr. Conklin was even legally allowed to be at Mr. Wyman's residence.
Not in this case.
So well, after we would say that after, I'll move on from that. As to Mr. Conklin's credibility, this is an individual. So Mr. Conklin, the complaining witness in this case. So from the police report, what we know, and from Mr. Conklin's testimony, is that when the two men arrived to do whatever they did at the house, which we're saying that John did not ask them to go there. Now,
You just told me he sent them.
what we're saying, he did not send them there to threaten. So
He sent them there, which is a violation. That third-party contact was not allowed. He had already served them. He then sent somebody back over there at his direction. The testimony is that he said, that Mr. Conklin said, is that Mr. Wyman sent him over there to lock the property up and get him out of the property. That was the testimony that he gave.
Your Honor, if I can continue, what we would draw into question is Mr. Conklin's credibility as to what actually happened. So I just want to like go through a little bit. So around 6:25 p.m., this was when Mr. Conklin and his kids returned. He asked, this is from the police report. He asked permission.
We can't testify from a police. You can't give argument from a police report to
Well,
me. You cannot give me argument on a police report.
Okay, I'm sorry, Your Honor.
Yeah, that's not evidence.
I'm talking about.
You can only give argument on the evidence that was brought forth.
So from the testimony, Mr. Conklin is saying that these two men had threatened him with a hammer. He did not see a weapon. There was no weapon involved. There were no threatening. No threatening statements really.
There was a threatening statement. He said that they threatened to use a hammer. They said we will hit you with a hammer. He did say that they didn't see the hammer. He didn't see a hammer, but threatening statements were made that based on his testimony. So that argument is not accurate as it reflects the testimony that was brought out.
And that's Mr. Conklin's testimony. We would argue that Mr. Conklin had a financial motive to fabricate or exaggerate claims. There's a financial motive to have my client locked up so that he can stay in his house rent free. That is essentially what happened in this case. And Mr. Wyman, he was a vulnerable individual during this encounter. Just lost his husband not long ago. I believe that the situation.
Who is this?
Mr. Wyman, my fault. So I'm just saying, I believe that this was a situation of a vulnerable person being taken advantage of. And I just think that the complainant witness here has a motive to fabricate.
Okay. You don't believe, though, that your client also has the same motive because this is his property. He owns it, correct?
He
No, he does not.
He was living there.
Yes.
He doesn't own the property.
He does not own the property.
Well, how is he doing an eviction?
It was a very imperfect process, Your Honor.
He doesn't own the property.
He does not.
How is he doing an eviction? How does he have a lawful right to serve a writ? You just argued that he had a lawful right. You told me that. You told me he had a lawful right in your argument. He doesn't own the property.
He has a lease.
No.
He has a possessory interest, Your Honor.
Yeah. How are you have a lawful right to issue a writ on somebody?
Your Honor, we don't believe the process that Mr. Wyman used. He was doing this on.
So it wasn't lawful. It was very vigilante.
Very imperfect.
It was very vigilante. I've heard enough. I've heard enough because I 100% believe that Mr. Wyman sent someone over there to lock this man out of the property. This has nothing to do with whether or not he was vulnerable. This had nothing to do with whether or not rents had been being paid or whether or not he had a lawful right to sublease. That really has nothing to do with that. This has to do with the fact that before me, he was arraigned. He was told not to go back to that property. He told me he was going to be staying with his father, gave me the address of 1508 Redwood. He wasn't staying with his father. He was staying with her. He then decided he was going to execute writ or issue a writ and have this man removed so that he can get back in the property. That's what this has to deal with. And after the writ was served, because she has already testified that she's gone and with someone else and recorded serving the writ without issue. If he had to let it stay there, he wouldn't be in this position. He then later sent someone back over there with his truck. He told me, that's why I asked the question I asked, because he evaded it when he was asked on direct. He evaded it when he was asked on cross. You're not going to evade it to me because I know what it was alleged that you told the police. And you allegedly admitted to the police that you sent the guy back over there. That's why I asked you that. Oh, yeah, I did send him over there because I thought, yeah, that's not what you said when you were asked by the prosecution. You said you didn't know he was going back over there. He did know he was going back over there. And if you are engaged in a criminal action and there's a no contact order and you then are moving forward with a lawful eviction, you must use a process server. Not some vigilante person you may or may not know, because one minute you say you don't know him, you just met him. Next minute you do know him. The other person will say he's a mutual offense, that he's a criminal and he stole. You definitely don't send them. And you definitely don't do a lockout. If you serve them with a writ, giving them 7 days, you can't now go lock the property the same day. So I'm sustaining the violation because he absolutely violated the conditions of the no contact order. Why is your hand raised? You should talk to your attorney. You can address the court once sentencing on the violation.
Your Honor, admittedly, Mr. Wyman has not availed himself to the courts in the way that we would expect him to, or by the rules of the court. It has been shown multiple times today that he is a very trusting person, and he doesn't necessarily have all of the faculties to go through this process in a legal and lawful way. I do believe that he is apologetic about that. We would ask this court to consider time served today. I do think he's been in custody now since the 15th of May. Thank you.
All right, want to make a statement?
Your Honor, I served him the writ and I sent Mr. Meisner over to lock my doors because he was not there, but I did not.
How'd you know he wasn't there?
Because Mr. Meisner came back and informed me that the house was locked.
If it was locked, why are you sending someone to lock the property?
He went over to lock the doors and then he came back.
How did you know to send someone over there to lock the doors?
How did I know?
Yeah. You don't live there, you don't have communication. How would you know if someone's in the property or not?
Because I told Mr. Meisner if there's a vehicle there, which was Mr. Conklin's, to not enter. And the vehicle was not there, so he entered that property because
Unlawful contact.
Mr. Meisner.
Unlawful contact.
But I did not send them. I was unaware that they went back.
Well, you sent them back. So you sent him to go lock the property.
One person, not
Doesn't matter. You can't send anybody.
right.
You couldn't send anybody. Do you understand that?
Yes, I do.
You're not allowed to send anybody.
Yes.
No third party contact.
Yes, and I was unaware of that.
No, you were aware that there was no third party contact. It says it in your release form.
I did not get a release form.
We went over your bond. I arranged you myself. I know what I said.
All I got was paper.
No contact, directly or indirectly, is what I said. And I signed the bond order. You didn't tell me you left the jail without a copy of a bond order. They don't do that down there.
All I got was a piece of paper that said I was due for pretrial. That was all I got.
There, and a PA 53 form was attached to it.
No.
They don't release you without a PA 53 form.
Okay.
You told the police that you thought it was okay to send somebody over there to lock the property. This was after the writ was served. I would have let you slide on sending someone to peacefully serve the writ, but sending somebody back over there to check to see if the property is vacant, and if there's a car there, leave. If there's not a car there, lock the door. You don't even know if he went to the store. You were doing a vigilante eviction, and you were trying to lock him out the property. And you can't make people believe anything other. I find that you did lack credibility when you tell me that story. I'll give you credit, time served. You've been sitting in jail for 30 days for this. Or yeah, just about. So I'll give you credit, time served. I don't want to have to reiterate your bond conditions to you. Do not try to play mince words with me. I arrange you myself. I say it like clockwork. You cannot have contact directly or indirectly with the protected party. At no time when I arrange you, did you tell me, well, Judge, I have a pending court case with him because I filed for an eviction. You didn't mention that. Am I allowed to have someone serve him? You didn't do that. At which point we would have directed you on who specifically could serve him. You didn't do that. You didn't mention any of those things. You also told me, I asked you, where will you be staying? We'll stay with my father. You per your bond conditions, have a requirement under the order to make sure I know where you're staying. And if you change it, you got to let me know in writing. Did you tell me you were going to be staying at her house?
I stayed at Miss.
Did you tell me? I'm telling her. She already testified you had been staying with her. Did you tell us that you were staying somewhere else?
No.
You probably ain't never stayed at your father's house since I let you out.
I was only out 2 days, ma'am.
I arraigned you on the 13th. When did this incident occur?
On 15.
On the 15th. You didn't say, you said you were going to stay at your father's house. That's not where you went.
Right.
You went to go try to do a vigilante process so that you can get back in the property.
No.
Yes, you did. Go back and forth with me again.
Well, that's okay.
That's smart. You're not allowed to have contact directly or indirectly with this protected party. That means you can't send anybody else to talk. You can't send anybody else to go check on him. You can't send anybody else to go stare at him. You can't send anybody to go lock any doors. At this point, he's testified that he's out of the property.
I understand.
And so you are allowed to return to the property if you're still a lawful renter or leaseholder on that property because he has testified he's not there anymore.
Correct.
But that still doesn't allow you to have any communication
Correct.
directly or indirectly. If he's at Burger King, you go to Wendy's. If he's at Kroger, you go to Meijer. You understand that?
Yes, ma'am.
There should be no confusion at this point, correct?
Yes, Your Honor.
Is there any other potential court cases that you have pending with him?
No, Your Honor.
Okay. Any other reason why you think you might want to try to send someone to check to see if his car is there?
No, Your Honor.
Okay. Any additional matters for the record?
Nothing wrong with people, Your Honor.
Not from defense, Your Honor.
Okay. You should be released today. You're all set.
The jury trial,
Thank you, Your Honor.
Jury trial date,
August 25th at 8.
August 25th at 8 a.m. in person at the court.